What's going on with gun laws in New York State? I'm going to tell you about it. It all starts with the New York State Rifle and Pistol Association versus Bruen case. Now, the Bruen case was a win for New York gun owners. The court determined that New York's proper cause requirement violated the 14th Amendment and prevented law-abiding citizens from exercising their Second Amendment right by making it illegal to bear arms in public. Now, the court determined that the right to bear arms in public for self-defense is deeply rooted in history, and for no other constitutional right is there a requirement of showing special need, like Kathy Hochul and the New York State government was requiring. Now, this case brought a very important text, history, and traditions test that would be used to support gun rights moving forward. In Justice Clarence Thomas's opinion, he wrote, "When a challenged regulation addresses a general societal problem that has persisted since the 18th century, the lack of a distinctly similar historical regulation addressing that problem is relevant evidence that the challenged regulation is inconsistent with the Second Amendment." In other words, modern gun laws that are put in place under the guise of addressing modern societal issues must have similar laws dating back to the 18th century. If not, the modern law does not meet historical tradition and is therefore unconstitutional. An example of this type of unconstitutional law would be the New York City handgun ban, because our founders did not have a law in place that banned handguns in densely populated communities for the purpose of preventing violence at the time of our founding. So Hochul and her gang of anti-gun thugs in the New York State legislature were sunk. Well, for 8 days or so. 8 days after the Supreme Court struck down New York's draconian gun laws in Bruen, Kathy Hochul signed into law the new Concealed Carry Improvement Act, or CCIA, which was nothing more than a new package of Constitution-violating gun restrictions. But this time, they were much worse. The CCIA was signed into law in July of 2022 and consisted of things like restricted carry areas, also known as sensitive locations, which basically turned almost every public place in New York State a gun-free zone. Also, enhanced background checks, including the submission of social media accounts for review as part of the application process. A mandatory training, which included a 16-hour training course and 2 hours of live fire training. A good moral character requirement, which required a more extensive review process compared to previous standards. Of course, New York State authorities would be the ones to determine who was of good moral character. Firearm storage requirements, requiring concealed carriers to store their firearms securely in homes, including a locked safe when not in use. Increased penalties, including criminal penalties, fines, and imprisonment for carrying in restricted areas. Restrictions on carrying in privately owned establishments unless the property owner gave consent or written notification allowing firearms on the premises, and other new restrictions. This new package of laws basically was a way of spitting in the face of the Supreme Court by deeming all private and public places gun-free zones unless those privately owned property owners gave specific consent. Not only was Kathy Hochul now able to regain control over gun owners and prevent them yet again from carrying firearms in New York City, but with her new package of gun laws, she was able to restrict the carrying of firearms across the entire state. Now, these provisions significantly impacted the ability to carry firearms in public spaces, and the law would go on to face much justified ongoing legal challenges. The CCIA has since been challenged multiple times in many cases. There have been preliminary injunctions granted against the CCIA preventing the enforcement of the restrictions. Several times, judges have deemed the requirements within the CCIA unconstitutional. New York State appealed decisions at the Second Circuit Court of Appeals, and of course, the left-leaning court would grant stays in favor of New York State, allowing the enforcement of the previously deemed unconstitutional gun restrictions. Since then, GOA, in the Antonyuk case, has sought emergency review from the Supreme Court. Now, the Supreme Court denied review and sent the case back down to the Second Circuit with a message from Justice Samuel Alito saying that the Second Circuit must either expedite hearings or issue a statement justifying their reasoning for issuing the stays. The Second Circuit would then hear cases, including the Antonyuk case, but not surprisingly, siding with the state of New York yet again. The Second Circuit Court decided that Bruen was an exceptional case, and therefore, precedent from Bruen was exempt from being applied to the cases in question. Now, when certain judges want cases to go their way, they always find ways to justify their decisions. In this case, what would appear to be in complete denial of the Constitution. GOA then filed a second petition to make sure the Supreme Court would hear the case once again. The Supreme Court granted, vacated, and remanded the Antonyuk case back to the Second Circuit again for a new decision in the light of the recent Rahimi decision, which was based on similar analysis to the previous Bruen case. Rahimi was the latest Second Amendment case, and the Supreme Court thought that its decision would provide new guidance. Again, the Second Circuit stood on their previous decision and decided that the Rahimi case did not change their mind. The Second Circuit Court released a statement saying, having reconsidered the prior decision in light of Rahimi and the party's supplemental briefing regarding the effect of that decision on our reasoning in this case, we now issue a revised opinion in Antonyuk. We reach the same conclusions that we reached in our prior consolidated opinion. GOA plaintiffs are now asking to reverse what the Second Circuit Court has said and have filed a petition for Supreme Court review. GOA's petition points out the Second Circuit Court's failure to apply precedents from the Bruen and Rahimi cases. In the petition, GOA makes the argument that contrary to the panel's insistence that Bruen was an exceptional case, warranting uniquely heightened historical stringency, Rahimi confirmed that Bruen simply explains the appropriate analysis. The Second Circuit Court has clearly been denying Bruen and Rahimi. This latest petition clarifies that and urges the Supreme Court to take action once and for all, putting to rest the draconian New York State regulations and destroying the so-called Concealed Carry Improvement Act. Shutting down the arrogant behavior of New York and refusing to let them violate the rights of New York citizens will send shockwaves across the country, reminding other blue legislatures of their obligation to uphold and protect the Second Amendment rather than defy and destroy it. Thanks for watching Bullet Points. I'm Dan Wass for Gun Owners Foundation. You can find more Second Amendment content and updates at gunowners.com.